everyone, and welcome to our summer session of our joint webinars between Taylor Wessing and Wilkie Farr and Gallagher. And thank you all for joining us. Today we decided it would make sense to talk about some recent litigation decisions that have come out affecting biologics and biosimilars in the U.S. and the EU. We have a team of people who will be talking today, two of our friends from Taylor Wessing, Christian and Matthew. And then from the Wilkie team, we have Sarah, Mike, Eric, and I from our New York and Chicago offices. And for those of you who are in the United States, definitely remember that if you're seeking CLE credit, you can click on the attendance sheet link that was provided. You can make sure you enter a code. Later on in the presentation, Sarah will be giving you a code and the time that you arrive and depart from the session. And if you have any questions or problems, feel free to reach out to any of us by email to help with that. But for now, I'll let us get into the substance of the program, and I'll hand it off to Mike Johnson, who's going to talk about a recent decision interpreting the BPCIA.
Thank you, Heather, and thank you, everyone, for joining us today. We appreciate everyone being here, particularly in these challenging times. So thank you for taking time out of your day to join us. The first decision that we're going to be talking about is a series of cases that were brought by Genentech against Amgen and some of their related entities related to the drug bevacizumab. Genentech also sued Amgen on regarding Avastin. And if anyone who follows this will know, Genentech sought a preliminary injunction in both of those cases. What we're going to focus on today was an interesting decision from the Federal Circuit, the decision in the Avastin case. In the Avastin case, Genentech sought a preliminary injunction based on an alleged failure of Amgen to provide their 8A notice. And the 8A notice under the patent dance framework in the BPCIA in the United States is the notice of commercial marketing. And so basically the statute provides that you have to provide at least 180 days notice before any commercial marketing of the biological product licensed under subsection K, and we'll see that that's going to be an important focus of this. Basically, what Genentech alleged is that Amgen had filed supplements to its original ABLA application. So these supplements related to the addition of a manufacturing facility that's an Immunex Rhode Island facility, hence the name of the case, and also a change in labeling. Genentech's basic argument was that this change in labeling required a new 8A notice. So a little bit of factual background. Obviously, Genentech manufactures Avastin. They sued Amgen on the original ABLA filings in August of 2018, and Amgen sort of immediately sent its 8A notice, which has been a common practice, particularly for older biologics that are outside their scope of regulatory, 12-year scope of regulatory exclusivity. So they send an immediate 8A notice after the filing of the BLA. They add these two third and fourth supplemental ABLA filings and ultimately end up launching their product or saying they're going to launch their product. Genentech seeks an immediate PI saying that basically every time they filed a new supplement, they were required to give a new 8A notice. So then the Federal Circuit addressed this in a recent decision. The Federal Circuit decided that no, Amgen was not required to provide a new notice of commercial marketing, a new 8A notice for each of the supplements, that the first notice of commercial marketing of the ABLA product, the licensed biological product, was all that was required. That's the most important holding to take away from this. And so basically the Federal Circuit affirmed the denial of the PI allowing Amgen to lodge. But their rationale for this is that in the view of the Federal Circuit, the obligation to give notice under Section 8A is tied to the biological product, which is defined as basically the active ingredient, the antibody in this case. And since Amgen's supplements only related to change in manufacturing facilities and addition of an indication, it didn't change the underlying biological product. They were still seeking approval for bevacizumab. And since there's been no change in the underlying biological product, the Federal Circuit decided that there was no obligation to give a new 8A notice, that basically the 8A only went to the identity of the biological product itself. So this was an open issue. There had been a lot of, at least commentary around whether or not sort of a supplemental filing would require a new patent dance altogether and or a new 8A notice in particular. And the Federal Circuit has resolved that issue, at least for now, saying that labeling and manufacturing changes don't count, and that the only thing that would require a new 8A notice was something that significantly changed the underlying biological product. The language is fairly clear, although perhaps in the future we could see if there was a change to the manufacturing process that perhaps changed the glycosylation pattern or other secondary or tertiary attributes of the protein or antibody. Could that give rise to saying it's a new biological product? So keep an eye out for that. This may not be over, but for now it seems that only one 8A notice is required, and that new supplements or new supplements to an existing ABLA do not at least trigger a further obligation to give commercial notice under Section 8A. So that was the Genentech Amgen dispute. I'll turn it over to Eric from our New York office to talk about some of the recent decisions related to patent thicketing.
Thanks, Mike. So before I get to the actual decision in the In re Humira case, just a little bit of background as to what the allegations were. As we've discussed on some previous webinars, one of the hot issues in antitrust law as it relates to pharmaceuticals have been these reverse payment settlements. And they're called reverse payment settlements because it involves the patent holder paying the accused infringer as part of settling an ongoing lawsuit. And these have been at issue, going back to the Hatch-Waxman Act back in the 1980s. In 2013, the Supreme Court weighed in on what the antitrust implications of these kind of arrangements might be in the FTC v. Activist case. And there they said that, where it appears to be there is a payment from the patent holder to the accused infringer in part of a settlement, that triggers what's called rule of reason scrutiny under the antitrust laws. And so that involves balancing the anti-competitive effects with any potential pro-competitive effects, and in particular, regarding the type of payment, they look at these factors relating to the size, the scale in relation to the potential costs of litigation, and as is really important in this one, the presence or absence of any other convincing justification. One other piece of background that has been discussed on previous webinars as well is that in the U.S., pretty much everyone except for the makers of pharmaceuticals thinks that drug costs are too high. It's one of the few things that Republicans and Democrats agree on, at least in principle. And last year, in 2019, this led to a bunch of congressional hearings. Those congressional hearings resulted in some bills being voted on and voted out of committee, but the actual impact on what the law is in the U.S. has been very modest out of that. But one of the side effects of those hearings is multiple congressional committees hold the makers of a lot of these very blockbuster drugs up to testify, including the president of AbbVie. This was one of their particular punching bags, was the Humira so-called patent thicket. And that is, for those of you who haven't been following closely, the Humira composition patent on the antibody adalimumab expired back in 2016 in the U.S. But AbbVie has amassed over the years around 100 different patents that they say claim or read on the processes for making adalimumab and the methods of treating people with adalimumab. And they've used those in BPCIA litigation to delay biosimilar entry in the U.S. So following those hearings, a bunch of the people who pay for a lot of the Humira in the U.S., that is the pharmaceutical chains, the people who fund large group health plans like municipal governments and unions, they filed a lot of antitrust suits alleging that what AbbVie is doing here was seeking to monopolize the adalimumab market in the U.S. And those cases were then consolidated into one multi-district litigation under the caption Enbrel Humira. And so what they were saying was that there were two main antitrust violations. First, they said that this patent thicket itself, when you aggressively assert these patents, that many of which the plaintiffs claimed were invalid, when you assert these in BPCIA suits, you are abusing your patent monopoly in order to extend your effective market monopoly beyond what you are entitled to under the normal patent grant. And then they also said that when they settled these BPCIA suits against particular biosimilar makers, that actually, the way they did that was an unlawful reverse payment settlement under FTC v. Activists. And so the payment that they alleged there was an immediate license to the patents needed to enter the European market in exchange for a later market entry date in the U.S. That was supposedly both the payment, and there was also a market allocation that the plaintiffs alleged was per se unlawful in the U.S. So that means a market allocation is, I say to my competitor, all right, I will exclusively sell this drug west of the Mississippi River, and you will exclusively sell the drug east of the Mississippi River, and so we'll divvy up the monopoly profits that way. So on June 8th of this year, the Northern District of Illinois issued an opinion granting AbbVie's motion to dismiss on all counts. On the patent thicket, they said that while the net result of this was that the consumers paid higher prices, it was not an antitrust injury. It was not illegal under the antitrust laws of the United States. What they had done was they had obtained patents, which is legal. They had defended those patents in the using the AIA proceedings at the PTAB, so IPRs and PGRs, and had asserted them in BPCIA litigation, which is exactly what they were supposed to do under the BPCIA. When you take all of that together, that means that they have done what's called lawful petitioning of the government. They have just done what is allowed by law, and under what's called the Noor-Pennington Doctrine, that cannot be the basis of an antitrust claim. On the reverse payment claims, the activist case says you have to use the rule of reason, and the first step of that is you have to show that there was an anti-competitive effect. But the court said, look, all you have alleged is that they have provided one early entry date for competition in Europe and a separate later early entry date for competition in the U.S. Neither one of those is an anti-competitive effect. It is, in fact, pro-competitive because people are competing before they would have been able to if they had to wait for patent expiration. And they also noted some public policy grounds for reaching that conclusion. And then finally they said it is not an illegal market allocation because what they're doing is saying that everyone will be able to compete with AbbVie on a level playing field in Europe on this date, and then everyone will be able to compete on a level playing field with AbbVie in the U.S. at a later date. That's not the kind of illegal market allocation that the antitrust laws ban. And so the end result is that while that may cause higher consumer prices, it's simply not illegal under current law, which essentially turns it back over to Congress to actually do something about it. And so now I'm going to hand off to Heather to discuss a recent decision relating to Enbrel.
Thank you very much, Eric, and thanks for that nice summary. I think a lot of people, particularly people who attend this call, who are interested in the intersection between the U.S. and Europe on these issues, were probably very interested to see that decision, particularly because of the point you made about the settlement affecting the U.S. and Europe not being a sort of market allocation. Because, and again, this is one court decision, but it's certainly going to be an issue that, you know, a lot of people who are global companies will want to have a settlement that might have one date in one country and one date in another. So that will be interesting. So I just wanted to give a few minutes to talk about another decision that's come out recently on a biosimilar of Etanercept. This case is Immunex versus Sandoz. Back in 2016, Hoffmann-La Roche and Immunex and Amgen sued Sandoz on a Hoffmann-La Roche-owned patent that's licensed to Immunex and Amgen. The patents in suit allegedly cover the compound itself and the manufacture of Etanercept. Etanercept is a fusion protein. It's used to treat rheumatoid arthritis, and it combines a 75 kilodalton TNF receptor with an IgG1 antibody. And this is often referred to as the P75 TNF receptor. And Sandoz sought to market a biosimilar version, and the court in New Jersey had a 2-week-long bench trial in fall of 2019 and came out with a very lengthy decision addressing this. And the court in New Jersey found that the patents in suit were valid, and Sandoz appealed. So I won't get into all the detail here, but if you read the decision, you'll see there's a lot of detail about the prosecution and ownership of these patents. Roche had originally filed these patents. Family back in 1990 had abandoned applications and filed continuations. There had been restriction requirements, things like that. And at the end of the day, these two patents issued in 2011 and 2012 and expire in 2028 and 2029. Back in 1990, Immunex and Roche had entered into a license agreement. Because what had happened is, although Roche had originally filed these applications, Immunex, working independently, had obtained FDA approval of Enbrel in 1998. Now later, what happened was that Amgen acquired Immunex. So in 2004, Amgen, Immunex, Roche, and non-party Wyeth entered into an accord and satisfaction agreement. And the reason that the details of this agreement are discussed in the decision has to do with Sandoz's obviousness type double patenting argument. So the court, both in the district court and the federal circuit, spend a lot of time just looking at what rights were allegedly acquired by Immunex under the agreement. Immunex basically bought out its royalty obligation, so it didn't have to pay continuing royalty. It received an exclusive license, the right to grant sub-licenses, the right to prosecute, and to sort of require Roche to participate in litigation. Roche had allegedly retained the secondary right to sue if Immunex decided not to sue for infringement, and a right to veto Immunex assigning the patent to a third party. So on appeal, Sandoz argued the patents in suit were invalid for three reasons: obviousness type double patenting, failure to meet written description, and obviousness. And I won't talk much about obviousness today. That wasn't as much discussed in the Federal Circuit. The obviousness type double patenting section is interesting because the court had to address two things. Do Roche and Immunex commonly own these patents? Because if they do, then arguably the Roche patents would be invalid for obviousness type double patenting over some other Immunex patents on methods of treatment. So to prove that, Sandoz first had to say there was common ownership and then actually meet the merits of the obviousness type double patenting. Sandoz said that the test for common ownership should be the all substantial rights test. Some of you may be familiar because that's the test used to determine if someone has standing to assert a patent. Either they own it or they have all substantial rights to it under a license. So Sandoz basically said, look, based on the license that Roche gave Immunex, Immunex effectively owns these patents. They have the right to prosecute them, the right to rectify any infringement, etc. Immunex and Roche disagreed, saying, look, Roche is still the owner of these patents. So that was the debate there. The written description debate had to do with how much disclosure of the P75 TNF receptor and fusion protein was in the specification. Sandoz argued that the P75 receptor in the specification was actually sort of a mutated and truncated version that wouldn't give you Etanercept. Immunex disagreed, said that there were enough sequence IDs and other information in the specification that a person of skill in the art actually could have gone to GenBank and gotten the full sequence of that receptor. Then there's some obviousness arguments that I won't get into now. So how did the Federal Circuit decide? The Federal Circuit decision was rendered by Judges O'Malley, Reyna, and Chen. And O'Malley and Chen found that the patent was not invalid for obviousness type double patent. All three judges agreed that the all substantial rights test is the appropriate test, so they agreed with Sandoz on that. But the majority found that Immunex did not have all substantial rights under that 2004 agreement that I mentioned. Judge Reyna dissented and actually thought that Sandoz had shown that Immunex had enough rights, particularly because it had the right to prosecute. So we'll see if anything further happens with any kind of appeal or anything, but there was a dissent from Judge Reyna. But at the end of the day, that decision by the district court was affirmed. All three judges affirmed the district court on written description, finding that there were enough blaze marks, so to speak, in the specification for a person of skill in the art to make the claimed fusion protein, and that you don't have to redescribe everything that was known in the prior art, including the P75 sequence. And then obviousness was also affirmed. That was just a more of a typical debate about nexus and things like that than the obviousness type double patenting and written description. So the decisions are very detailed, and if you're interested in these issues, I would suggest taking a closer look at them. Now I'm going to hand it off to Sarah, who's going to talk about a slightly different topic relating to the ITC.
Thank you, Heather. I'm going to talk about the Section 337 of the Tariff Act decision regarding certain botulism toxin products. So here we're talking about a follow-on actually to a biologic related to Botox. On these webinars, I understand that there hasn't been very much discussion of ITC practice, but here this is an interesting case to watch for a couple of reasons. One, the ITC is not often a forum of choice in the biopharma space, although we'll see if that changes going forward. And not often is the ITC used for trade secrets. And here we have a combination of both of those things. So it'll be interesting to see what happens next in this case, which also has some interesting global aspects and criminal aspects, actually. So a brief summary of what a 337 investigation is and how it works. The International Trade Commission is a U.S. federal agency with the authority to adjudicate cases involving companies that domestically exploit their U.S. IP rights, and then those who infringe on those rights by importing other products. So it has to be, there's a certain domestic requirement here for the U.S. that the company invoking the investigation has to be doing something, domestically on U.S. soil and trying to keep an infringing product out through the borders. Here, in an ITC investigation, the complainant, who is like a plaintiff in a district court litigation, can seek to have an investigation of certain respondents who are like defendants in litigation for doing things like unfair methods of competition and unfair acts, importation into the U.S. of articles that infringe patents or trademarks. Different from district court litigation, all of the remedies are related to importation, general and limited exclusion orders, cease and desist orders, but there can be no money damages. The proceedings move very quickly at least in comparison to district court litigation or even patent office proceedings. And as we go through the timeline of what happened in this case, you will get to see that. So what happened here? In January of 2019, a complaint was filed by Meditox and Allergan. Allergan is, of course, who is the brand who sells Botox. Alleged violations by Daewoo Pharma and Evolus in their importation and sale of products that they say violated trade secrets that they had. So Allergan is the manufacturer of Botox and exclusively licensed Meditox to market and distribute a certain product in the United States. Those companies say that Daewoo stole trade secrets, misappropriated trade secrets, and specifically alleged that a former Meditox employee took confidential documents describing a manufacturing process for the product and an actual sample of the strain of the botulism used for the products before leaving Meditox in 2008. This Meditox employee then began consulting with the respondent here, Daewoo, as early as 2010, and allegedly used the stolen trade secrets to develop Daewoo's follow-on biologic to the Allergan Botox product. So the complainants here, Allergan and Meditox, seek an exclusionary order and a cease and desist order. So interesting here in the global component and also domestically is that Meditox had brought cases in Indiana and California state court for in relation to violation of misappropriation, of the of trade secrets, but those were dismissed on forum nonconvenience grounds or stayed pending the legal actions taking place in Korea. And it's sort of dramatic, and you can Google more about it if you'd like to know more about it. But the former employee and Daewoo are actually subject of ongoing criminal investigations in Korea as well. So to highlight the quick nature of how these things progress in the ITC, just over a year after the complaint was made, the ITC held a 4-day trial. That's actually a long time for the ITC. So that means that you can think what you want about that, but it means they actually took a lot of evidence on this issue. And then earlier this month, ALJ Shaw issued a final initial determination, which is that ALJ's basic, their preliminary decision of what should happen in the case. And the ALJ found that a violation of 337 had occurred by reason of misappropriation of trade secrets. That final initial determination is still under seal. It hasn't yet been made public as of this morning. We'd expect that it would become public in the next week or so, and that the parties are still hammering out the details of what redactions should remain in the public filing of that decision. But the press releases of the company give us some insight as to what the ruling said, and that is that Daewong's product is banned from entering the United States for the next 10 years. Interestingly, because trade secrets are not often used as a basis for a complaint in the ITC, the 10-year thing will be something that we, will look forward to understanding how the 10 years was determined. As everyone knows, trade secrets can be indefinite in time. They don't have an expiration like a patent or a copyright or a certain other IP. So we'll be interested to see how the ALJ determined 10 years was the appropriate amount of time for the order. So what happens next? The full commission will review the initial determination. The target date is November 6, 2020. So again, showing the quick nature of how these things progress. We'll have a final determination by the ITC in early November of this year. That's actually even after the deadline was extended once, which the ITC typically does not do. After the ITC's final decision, the exclusionary order is subject to review by the president, who does have veto power, and then any appeal of the decision would go to the federal circuit. So this is something to keep on your radar. I suspect in coming days or maybe next week we will hear more and see more about what the actual decision was, but we thought we should note it for this group because it does involve biologics and also using the ITC as a forum for trade secret misappropriation determinations. Next, I have the pleasure of reading all of our U.S. colleagues the CLE credit code. So if you are on the phone and hoping to receive CLE credit, please write down this code. It is WFG space 1569. That's WFG space 1569. At the end of the presentation, there will be a place in the form for you to add that code, and that will ensure that you are allowed to get the CLE credit. And next, I will turn it over to Taylor Wessing, and I think Matthew Broyle for a discussion about what's happening in Europe.
Thanks very much, Sarah. That's great. So yeah, we move across to Europe. I'm going to start with a report on a biologics case that has reached all the way up to the Supreme Court in the UK, and then I'll hand over to my colleague Christian de Koning, who is going to give us a brief update on some developments in Belgium, and then finally I'll say a few words on the UPC and the state of play with that. So there have been a number of key decisions on patent law from the Supreme Court of the UK in recent years, and Regeneron and Kymab is the latest one, and it was handed down earlier this month. It addresses sufficiency in the context of transgenic mice expressing genes from the human antibody variable regions in what's called a reverse chimeric locus. Now, sufficiency is one of those areas of patent law where many questions tend to lead back to the public policy sort of approach, which is why patents are justified in the first place. And this is a good example of that. And this policy is often referred to as the patent bargain. And it has a number of features, but it's based in exchange for a period of exclusivity. The patentee should disclose enough information or sufficient information to the public that their invention can inform the public for the benefit of the society and can be used going forward. This is effectively codified in UK law in section 72(1)(c) by allowing the court or the controller to revoke a patent if the specification of the patent does not disclose the invention clearly enough or completely enough for it to be performed by a person skilled in the art. The skilled person must be able to perform the invention disclosed without undue burden. And this means that they're entitled to make some trial and error experiments using their common general knowledge in order to get the disclosed invention to work, but they have to be able to do so across the full or a substantial part of the monopoly claimed. Now, there's also an established principle that the disclosure of how to perform one embodiment of the invention will be sufficient to support other embodiments claimed if it discloses a general principle or principle of general application, which will work in respect of all of those embodiments that are covered by the claim. And this is where the Supreme Court decision in Regeneron and Kymab comes in, because it essentially deals with this rule on the principle of general application and how, I think following the Court of Appeal decision, it becomes somewhat detached from the basic enablement requirement. So I'm going to look first at what Regeneron and Kymab is about and what the lower courts did before then discussing the Supreme Court decision. So at first instance, there was a lot of evidence on the technology and the issue in the case. I've reduced this to what is needed to understand what the Supreme Court has done, but hopefully in doing so, I haven't glossed too much over the science. There are actually two patents in issue in this case, and the first was a parent of the second, and so they both had substantially the same disclosure, although the claims did differ. The parent was EP287, and this claims a method of modifying the antibody variable regions of a mouse cell DNA by replacing the mouse antibody variable genes with the equivalent human genes. That is the human antibody light chain V and J, or variable and joining regions, and the heavy chain V, D and J, or variable diversity and joining regions. Whilst the mouse retains its mouse constant regions. And this is where you get the concept of a reverse chimeric locus. So the method described in this patent uses sort of particular targeting vectors for use in eukaryotic cells, which are designed to introduce particularly large fragments of cloned genomic DNA. And then they combine that with a particular assay of that looks at the modification of the allele. But in short, this patent covers a method of humanizing the variable regions of the mouse antibody to create this reverse chimeric locus, in which the grey areas in the picture on the slide are human and the rest is mouse. So the second patent in issue was, as I mentioned, a divisional of the first patent on the previous slide, EP163. And it was actually claim one of this patent that the Supreme Court ended up focused on. And this claims a transgenic mouse that results from the process of the parent patent. And that mouse contains the reverse chimeric locus. So in short, it claims a mouse producing effectively antibodies with human VD and J regions due to that reverse chimeric locus. Now, as an aside, because nothing actually turns on it in this case, the genes for these regions undergo rearrangement during the B cell maturation process in the mouse. And this is what's shown in the picture, as well as also the process of somatic hypermutation, which introduces potentially dozens of mutations in the variable region, and this allows the diversity that's needed for particular specificities of the antibody. The hybrid antibodies that are produced by these techniques they're not the final therapeutic product because they contain mouse constant regions, and if those were administered to a human, they would be liable to induce the human anti-mouse antibody or HAMA response. But actually, this doesn't matter very much because using genetic engineering, it's possible to produce fully antibodies by effectively replacing those mouse constant regions with human constant regions. What really matters, and what's important to remember for this case, is that by virtue of having this reverse chimeric locus, so retaining the mouse constant regions, the mice produced are not immunologically sick. So that means that their ability to produce antibodies across the full spectrum to a number of different antigens that are inoculated into the mouse is not compromised. And this was a significant inventive advance compared to the techniques set out in the prior art. And I mean, it was the central issue in the decisions of the Court of Appeal and the Supreme Court that we are concerned with. So, at first instance, the late Mr. Justice Henry Carr had actually held the patent insufficient for a different reason to the Supreme Court, for what I'm calling on this slide the first issue. So Henry Carr had held that the method of the 287 patent was insufficient on the classic ground, which means that it was not capable of being performed at the priority date without undue burden and without invention. As a result, the judge also held that the product claims issue, in this case the EP 163 patent, which relied on the method, were considerably wider in scope and so must necessarily also be insufficient. A specific aspect of Henry Carr's findings focused on claim 1 of EP 287 and the relevant example 3. And it was, they required techniques in which the mouse DNA sequence would be replaced with the equivalent human sequences. And those sequences were too large to be possible at the priority date using the vector method that was described in example 3. The alternative technique of example 3 used recombinase mediated cassette exchange, and that would also not have worked. And furthermore, sort of one final nail in the coffin of being able to produce these mice at the time was that Regeneron's own scientists had not been able to produce the mice at the priority date. So the Court of Appeal agreed with the trial judge that example 3 wouldn't have worked at the priority date, but it overturned the judge anyway on the insufficiency point, and that was because the Court of Appeal found that the common general knowledge of the skilled person or team could be used to make the invention work without undue effort, even if this meant teaching the patent was not followed precisely. So, in particular, expert evidence from the trial, which actually the judge had not been considered, or had not considered in this context, and actually hadn't been put to him in this context, suggested that the skilled person would have considered it obvious to use techniques known at the priority date to shorten the inserts to a manageable size. And this is called the mini-gene approach, and it involves taking out sort of non-essential DNA sequences such as introns to reduce the size of the of the DNA sequence that needs to be added to the mouse. And these techniques, according to the Court of Appeal, provided the necessary support for the claim, even though they could produce only a hybrid gene structure with a small subset of the 125 human V segments in the variable region, an unspecified number of the D and J segments. So transplantation of the whole of the human variable region into the hybrid gene structure, which was sort of taught by the patent, would not be possible. And apparently this has only since been achieved by, for instance, Regeneron and Kymab, by further inventive processes that are not part of the disclosure of these patents. So there was a second issue concerning sufficiency, and this is the one that made it to the Supreme Court. The second issue was one of the principle of general application. This concerned the fact that the mice could only be made containing a small range of the human variable regions possible, even allowing for the common general knowledge techniques that I've just explained. The product claims, however, also claimed a mouse producing antibodies with all possible human variable region combinations, including full-length human variable regions. And the claims therefore covered a mouse which would not be capable, which would be capable of covering many, many antibodies that could actually not have been made at the priority date. But the Court of Appeal held that this didn't render the claims invalid because of the established rule of a principle of general application. In this case, the Court of Appeal held that there was a principle of general application, and this was the reverse chimeric locus, and that prevented the mice from being immunologically sick. And this principle would apply to all of the mouse covered by the claim now or in the future, and as such, the claim, according to the Court of Appeal, was sufficient to cross its breadth. So this, as I said, is the one that made it to the Supreme Court. What did the Supreme Court say? Well, it actually overturned the Court of Appeal in a majority decision, 4-1. Lady Black dissented and would have upheld the Court of Appeal's view. But Lord Briggs, giving the leading judgment of the majority of the court, extensively reviewed the authorities and set out 8 points of principle that apply. So firstly, the requirement of sufficiency exists to ensure this, that the monopoly conferred corresponds with the extent of the contribution made. Secondly, for a product claim, the contribution to the art is the product itself, so in this case, the mouse, rather than the invention, either the reverse chimeric locus. Thirdly, patentees are obviously free to choose how widely they frame their claims, but they shouldn't claim them more broadly than they've enabled. Fourth, the sufficiency must cover substantially all types of embodiments of products claimed, so not necessarily all of it, but substantially all of it. Yes, if the product cannot be made, the patent will exceed in contribution to the art. 6, principle of general application can be relied on, but only where it would appear reasonably likely to enable a whole range of products to be made. And 7, enablement across the scope of the claims applies only across a relevant range. So I think the example used in the judgment is a mouse's tail. The mouse's tail length is not a relevant consideration, so it shouldn't be taken into account. And then finally, 8, showing that if and when they can be made, all the products will deliver the same general benefit is not enough if they can't actually be made. So it's important to note that the court reiterates that the requirement of sufficiency imposed by Article 83 of the European Patent Convention exists to ensure that the monopoly corresponds with the extent of the contribution which it makes to the art. And that's the key. the contribution to the art of a product claim, in this case, is transgenic mice containing the reverse chimeric locus. It's not the inventive concepts that the mice produced are not immunologically sick. The latter, the inventive concept, is just an idea. And if an idea can't be made, then it's not a technical contribution to the art at all. So in short, the Supreme Court reiterates in Regeneron and Kymab, in the context of a class claim to transgenic mice, the patent bargain. A patent cannot claim products that it does not yet tell you how to make. And with that, I will hand over to Christian to give an update on Belgium.
Hi everyone, very short update on Belgium, I promise. I just want to highlight that in Belgium, although several biosimilars are available and reimbursed, the market share of biosimilars in Belgium remain quite low, certainly compared to other European jurisdictions. This is clear from the graphic that I've shown on the slide, and which is taken from the Belgian journal Acta Clinica Belgica, and which shows the biosimilar market shares in Belgium for the years 2015 to 2019. And it's clear from this graphic that for most biosimilars in Belgium, the market share is well below 20%, except for filgrastim and infliximab. And the reason why this market share is so low in Belgium has been a topic of debate for some time now, and one of the reasons could be the litigation system in Belgium, and the rituximab case is a nice example for this explanation. In 2017, Biogen, Roche, and Genentech launched PI proceedings based on their EP304 patent, which relates to the use of rituximab for the treatment of joint damage caused by rheumatoid arthritis for a specific subpopulation of patients. It's more for a retreatment, in fact. And they launched these proceedings against Mundipharma, who wanted to provide biosimilar rituximab on the Belgian market. Even though this patent the validity was questionable, to say the least, and this is clear from several elements, among others, the fact that the opposition division had already issued a negative preliminary opinion in a pending opposition procedure. The patent owners had de-designated the UK from their patent application, which you usually don't do if you have a really strong patent. They had redrawn PI proceedings in Italy, which in practice only happens if the court-appointed expert files a negative report. And the Dutch court of The Hague had already issued a decision on the merits in first instance, invalidating the Dutch part of EP304. Nevertheless, the court issued an injunction against Mundipharma in 2017, arguing that the patent was prima facie valid. It took to September 2019 when the court decided on the merits and invalidated the Belgian part of EP304 to lift the injunction. So for 2 years, more or less, Mundipharma could not provide rituximab biosimilar on the Belgian market because of a patent that in the end was invalidated. And not surprising at all, in a sense, which is also something typical for Belgian case law, the Belgian Court on the Merits followed the lead of the opposition division and invalidated the patent for more or less the same reasons as the opposition division. Added matter was the reason to invalidate the patent as granted, and the auxiliary requests lacked inventive step. So 2 years based on a patent that was in the end invalidated, and in view of the latest case law of the European Court of Justice, it will be very difficult to obtain damages to compensate for these lost 2 years. So this could be one of the reasons that the market share of biosimilars in Belgium is quite low, but that cannot be the whole explanation. And that's why the Belgian Competition Authority launched an investigation in October 2019 on the conduct of several pharmaceutical companies in relation to biosimilars. It was all over the news in Belgium that in October last year, the Belgian Competition Authority then raided the Brussels offices of Roche and of several university hospitals in Belgium, and their focus is on the conduct and agreements they have with each other on the supply of biologics and how they use certain techniques to limit the availability of biosimilars in Belgium. This investigation is still ongoing, so anyone here present who has interest one way or the other can still file some comments with the Belgian Competition Authority should they have any experience in this regard with regards to the supply of biosimilars in Belgium. It's not a litigation decision as such, of course, but it will result in interesting litigation decisions relating to biosimilars in Belgium. So that was short as promised, and I give the word back to Matt for the UPC.
Thank you very much, Christian, and just a very short word on the UPC, which, as I'm sure you all know, is a single patent court which is intended to cover sort of 25 jurisdictions. There have been sort of various bits of bad news for the UPC project recently. So on the 20th of July last week, the UK officially withdrew from the UPC agreement. And then sort of just before that, on the 13th of March, the Federal Constitutional Court in Germany decided that the decision to ratify the UPC was unconstitutional and was therefore null and void. So the UK and Germany are both sort of necessary, or it's mandatory that both of them ratify the decision. So that's problematic for the project going forward. But there was another point left outstanding in the Constitutional Court decision in Germany, which is whether an unconditional primacy of union law required by Article 20 of the UPC agreement violates German basic law. Now, the court didn't answer that in the constitutional complaint of the UPC, but has answered it in a different context in relation to European Central Bank bailout policy, where it said that German basic law has sovereign power over EU law, and that would be, I think, very problematic for the UPC, for that article of the UPC agreement. So at the moment, the rumours are that the Bundestag will repass the bill to ratify the UPC, but that might not be the end of the matter, because internationally there's a question of whether the agreement will need to be renegotiated. As I mentioned, the UK's ratification is mandatory, and London was also set to be the seat of the Life Sciences Division. And those changes have to be agreed by all the other signatories, and the seat of the Life Sciences Division in particular might be contentious. You may have followed the fallout from the decision to move the EMA to Amsterdam rather than to Milan, and sort of the contentious nature of those discussions. But also domestically in Germany, it seems that any decision would have to be referred back to a constitutional court to decide this issue about whether the German basic law should be sovereign over EU law. So even if the UPC does get over those hurdles, it's going to take several years, and the UPC project will at very least be delayed still further. So with that very sort of quick update on the UPC, that concludes today's webinar. Thank you very much for joining us. It just remains to thank our speakers, Heather Schneider, Mike Johnston, Eric Saunders, Sarah Horton, and Christian DeConnick. Please do hang on for a second after the end of the webinar just to fill in the questionnaire. It's good to hear your views, and it may well shape what we talk about in our future webinar, for which please do look out for the invitation, because we're going to be speaking to you again in the autumn. If you are from the US and you want CLE credits, please do now fill out your form, which I think there is a link for you on your screen. But otherwise, thank you very much for joining.